My panel is constituted that does have Counsel Eron Kizza and Major Retired Awich, Director External Affairs of the NRM. Counsel, you have refused to proceed with the case until the lead counsel, Martha Karua, is added to the team. What will happen if government maintains its stance?
Government cannot amend the 1995 Constitution. So if it wants to amend it, we shall understand before it amends it, the right to a fair hearing is sacrosanct, non-negotiable, and non-derogable. We are not going to budge on that one.
Regarding this particular stance, in whose interest is the legal team working? Besigye's or his lawyers?
The legal team is working in the interest of Besigye as microcosmic of the interests of Ugandans.
Very interesting there. Now, Justice Minister Norbert Mao says that the Honorable Martha Karua can appeal against the Law Council. Is this something you should expect and that you are considering?
Yes, but there are many options on the table. We could appeal, could reapply again, where Karua has already engaged the Law Council, and they should revert to her on her clarifications, but there is no time for waiting to condemn in the strongest terms possible the Law Council doing politics instead of doing law, and theming their ruling with irrelevances, inadequacies, and fundamental flaws.
Okay. Let me bring in Major Awich here. Regarding what is happening and events unfolding in the Besigye case, from the best of your understanding, are these matters law or matters politics?
The events at the court martial, which includes the alternation between the defense counsel, Mr. Kizza, and others on one hand, and the prosecution on the other hand, may appear like politics, but in my opinion, it's a matter of law. For the reason that whatever they are raising within the confines of the law. And what will happen is that whatever argument that is brought, the court is hearing, and it will at one point crystallize into the findings of the court or the ruling of the court. So normally, some lawyers present their cases in a dramatic events in a way that they feel they can package for the court to hear, but in all, it is law. And I would like to remind viewers that people think court martial, that is the general court martial is the last. There's appellate court after that, the court martial appeal, and also this court joins in the wider civil courts for appellate system up to Supreme Court. So whatever is happening is purely matters of law.
As somebody dealing with external affairs, you'd interest yourself in knowing, and I think you do, that the Law Council of Kenya has written a protest note to Uganda Law Society. Where does this leave the General Court Martial?
The protest letter is between the two councils, and Court Martial has no power over Law Council. So I find the import of Court Martial in the alternation between the two Law Council and called for, because it is a matter between the two Law Council. Law Council has mandate, a discretionary mandate to decide who they issue the certificate. So the court martial should be out of this, because it doesn't have any effect on court martial, because it is a matter between the two Law Council, the Law Council of Uganda and the Law Council of Kenya. So the import of the court martial is uncalled for.
Counsel Eron Kizza, Uganda does train brilliant lawyers and has plenty of those. What makes you believe and think that those are not enough? Even in the event of the denying of the practicing certificate, we do know from sources that there are even more lawyers coming from Angola and some other places.
Even another one from Kenya, lawyers from Tanzania are coming, but it's not a matter of opinion, thought, or belief. It's a matter of fundamental human rights of their choosing to choose their lawyers. It's not for the Law Council or for the court martial or for President Museveni, who is misusing this kangaroo tribunal to get back at his political foes, to choose the lawyers, the number, and the manner of legal representation for the accused. Having purported, pretended, and attempted to try civilians in a kangaroo military tribunal in defiance of and in contempt of court, they should at least have a modicum of respect for human rights laws.
Major Awich, we now see continuous adjournments because the defense team is not fully constituted. What do you think is the best option for the General Court Martial?
In simple terms, suppose the defense team disappear altogether. You see, I am an advocate of the court of law, but I'm also a retired army officer. So I've had interface with court martial over a long period of time from my childhood. The spirit which is in the constitution of providing a representation, say in capital offenses, was long carried in the army in NRA time. NRA believes in representation. For example, at unit level where we have the lowest court, a soldier is represented by a political commission and the prosecutor is the IO. Even at court martial, by the way, even if Kizza Besigye didn't have defense team, court martial has a standby defense counsel in court martial. Only that now persons like Kizza Besigye may not trust the defense counsel, but the court martial can proceed without even civilian lawyers in this case, because court martial has in itself inbuilt a defense counsel system, which, as I said, starts from the lowest court in a battalion to a brigade. Now, at the court martial, there's what is called a defense counsel, provided by the state, provided by the army, and paid by the army. So, if the lawyers for Dr. Kizza disappears forever, for example, as they're saying they can't move in the absence of the Kenyan lady advocate, then the court, one option the court has is to continue with his own court defense counsel, or if Besigye objects to that, then the court can proceed and it will deliver its ruling. And as I said, then maybe Besigye can pick from that with an appellate ground.
Counsel, finally, very briefly, it seems that each side is dug in. You're not proceeding until your lead counsel has a practicing certificate. The General Court Martial is happy to continue with the adjournment. Is this a classic case of let's continue with this and see who will blink first?
Yeah, we are not playing around. We are asserting rights. They are non-negotiable. They are sacrosanct. They are non-derogable. We are holding the Constitution, the right of the Constitution, to the Kangaroo Military Tribunal to see whether its darkness will melt away. If it doesn't, we shall see what to do. We are also praying to God, and we hope for divine intervention in this matter. But whatever happens going forward, for us, we shall continue holding onto our Constitution and telling those soldiers that they have their place is in the barracks and not intruding into the civilian space of delivering justice.
Thank you, both gentlemen, Counsel Eron Kizza and Major Retired Awich Paula. Ours is to host the guests. The opinions